Good afternoon, and welcome to another Richards and Jurusik webinar. Today, we will be discussing TN visa to green card and what that process looks like and what your options are if you're on a TN to potentially move to U.S. permanent residency or a green card. And as always, if you've tuned into any of our webinars, we like your questions, so feel free to submit your questions throughout our conversation in the chat, and we will address those at the end of our discussion. So we'll go from here. My name is Jeremy Richards. I am an attorney with Richards and Jurusik, where we only practice U.S. immigration law. And I'm here along with Rebecca.
Hi, everyone. I'm Rebecca. I'm an associate attorney here, and I primarily focus on family and business applications.
So today, Rebecca and I are going to give you the rundown on how to go from a TN visa to green card. So we're going to cover the pathways to a green card from a TN visa, the common employment-based pathway for that process, which is through PERM, as well as family-based options to a green card, and the differences between adjustment of status and consular processing when it comes to moving towards U.S. permanent residency, maintaining your status during the process and the importance of that. And then we'll also just give you a view of the upcoming webinars that we have. So the two most common ways to go from a TN visa to a green card are the same pathways that you would see if you are in the United States under any non-immigrant visa. And that's I guess, a fiction that we would like to put to rest, that you can't go from a TN visa to a green card. Well, actually, yes, you can, just as you can go from a visitor visa to a green card, a student visa to a green card, an H-1B visa to a green card. They all actually follow the same process to go to a green card, depending on what your options are, whether it's through employment sponsorship or family sponsorship. Those options exist for non-immigrant visa holders, the same for those under TN status in the United States. So it's either through being sponsored by an employer or being sponsored by an immediate family member that qualifies to sponsor you. So we're going to cover the family-based sponsorship options, and Rebecca will jump in when we get to that point, going from a TN from a marriage to a U.S. citizen. And the benefits of that process, including no visa bulletin wait time. It's a much faster path if you're doing it through marriage to a U.S. citizen, as well as the employment-based options. The most common one is through labor certification and an I-140, as well as, and then the categories you typically are going to fall under there are the EB2 or EB3 categories. And also some considerations. TN visa is a non-immigrant visa, which means that you need to be careful about the process. So someone just put in the chat, what about NIW? Well, NIW is an option. There are some self-sponsored options. Those really warrant their own conversation. So there is NIW and EB1A that are also potential options that you can do self-sponsorship to go to green card as well. We're not going to go in depth about those because, again, those warrant their own conversation. But if you pay attention to our discussion today, the process of you just throw that NIW or EB1A under this employment-based sponsorship option, it works the same way. So if you pay attention to how to go from a TN to green card through the employment-based option, well, your NIWs and your EB1As are going to also fall under that same process, okay? And you could also throw in your outstanding professor researchers. They would also fall under that same procedure to go from TN to green card. The advantage is if you're doing an NIW, an EB1A, or outstanding professor researcher, is you don't have the labor certification. But the rest of the steps, the I-140, the I-485, and the way it looks to go to a green card are exactly the same. So maintaining non-immigrant intent, and when you're declaring non-immigrant intent as far as the TN visa process and the green card process is very important. As a TN holder, you should always be declaring non-immigrant intent on your entry to the United States. Now, intent can change. It's a fluid thing. You can go from non-immigrant to immigrant intent as long as you do it at the right time. So timing is very important as far as your intent in this process. And when you change intent and understanding when your intent changes. Your intent is only declared for immigration purposes during a few steps in the process. And that influences how you want to complete the green card process, either consular processing or adjustment of status. So that intent for immigration purposes isn't really declared until either one of those steps is commenced in the process. And it's important to avoid immigrant intent or declaring that if you're at the border. What some people don't understand is that intent, when it comes to this process, is only declared when you're filing either that I-485 adjustment of status application or you've commenced the visa process with the National Visa Center and you've commenced consular processing. An I-140 does not establish intent, as well as an I-130, if you're doing a family-based petition, does not establish intent. Neither does filing an NIW or an EB-1A or outstanding professor researcher. Those forms are all filed in order to classify you in a category that could potentially qualify you to then request a green card. So having an I-140 or an I-130 alone or doing the perm process alone does not establish immigrant intent. You also need to understand that an I-140 and a perm isn't even filed by you as an individual, and neither is an I-130, right? These are all filed by people that are sponsoring or petitioning you. So as the beneficiary, you haven't filed anything in this process. So your intent isn't declared until you step in, and that's either, again, through that adjustment of status process or that consular processing. Until then, you are just simply trying to be classified as an individual who could potentially qualify for a green card based on that classification. And even if approved, you don't ever have to act on it. You may never act on it. Just because you have an approved I-130 or an approved I-140 doesn't mean you're going to eventually follow through and apply for the green card. So very important to understand how intent impacts this process. And travel risks too. You need to understand that when certain steps are taken in this process, you aren't going to be able to travel if you're going from a TN to a green card. If you're doing adjustment of status and you've filed that adjustment of status application, you will no longer have the ability to depart the United States. So timing is very important to make sure your TN status is valid for a long enough time period to cover that adjustment of status process. And that's where a lot of individuals will make that decision between consular processing and adjustment of status. If you're consular processing, you maintain the ability to travel back and forth while you're waiting for your consular appointment. Whereas adjustment of status does not allow for travel. So when it comes down to that decision of do I consular process or do I adjust? Well, there's two key factors people usually consider. Do I need to travel and maintain my ability to travel throughout the entire process? Also timing. How long is it going to take? Well, adjustment of status can be much quicker than consular processing. So individuals often go towards adjustment of status because they want their green card faster. And in some cases, people have to maintain that ability to travel. Well, if that's the case, then you may be stuck with consular processing because it's the only way you'll be able to travel throughout the process. So those are some key considerations in the process: intent, how it impacts your travel, how it impacts the process of your case. And in the end, how fast it processes is going to come down, and we've discussed this in the past, to your country of birth. Country of birth is going to dictate your place in line and how long this is going to take. So employment-based green card through perm. There are 3 distinct steps in this process, and I covered them briefly. So the first step is what is called labor certification, and that's where your employer is going to do what's called a test of the labor market. Your employer is going to follow certain procedures with the Department of Labor to post ads in certain locations and verify whether or not there are what are called willing, able, and qualified U.S. workers out there for your position. Essentially, what your employer has to prove is that there are no U.S. workers in your area of intended employment that are available to take that position and fill that role. If they go through this recruitment process and they can prove that they've advertised in the appropriate mediums and that no U.S. workers want the job, then that allows your employer to move forward with the green card process. So very important to understand this first step is with the Department of Labor. It is not attached to you at all as a foreign national. This does nothing to your TN status. You have not declared anything. There's nothing that they're going to be able to pull up and identify that attaches to you as far as the perm process. This is something that's very independent of your TN. So we get that question a lot. Well, how does this perm impact my ability to extend my TN or travel? Well, it doesn't at all. You can continue to travel through the perm process. You can continue to extend your TN through the perm process. It has no bearing on your ability to extend your TN. And just keep in mind, this is something your employer is doing, not you. Your employer is doing this test of that labor market. So once they do that test, they submit their findings to the Department of Labor. Then the Department of Labor will review it, and if they think everything is in order, then they will certify that application. And once it's certified, that allows your employer to then take step 2 in the process, and that's the immigrant petition. And that's where the employer then takes their findings, their certification from the Department of Labor, your qualifications or the qualifications of the employee they want to offer this permanent position to, and they submit it to U.S. Citizenship and Immigration Services, who will then review all the documentation. USCIS's role here is to verify that the foreign national who's being offered this position meets all of those minimum qualifications for the role. If they verify that you have the proper education, licensure, experience, and that all checks out, then they approve that I-140. Again, the I-140 here, it doesn't give you anything per se. All it does is say that you're approved now, that USCIS has verified the certification from the Department of Labor. They've verified the qualifications of the foreign national, and they say that everything checks out. And then with that approval, what it does is if you're EB2 or EB3 or EB1A, NIW, whatever your category is, then you'll get a priority date. Actually, the priority date will retro to the filing of that labor certification. So you actually get a priority date at the filing of the labor certification if one is attached to the process. If it's an EB1A, NIW, outstanding professor researcher, then the priority date isn't attached until the I-140 is filed. So EB2, EB3, your priority date is actually attached when the labor certification is filed with the Department of Labor. So you get your priority date a little sooner as far as that goes, that you get it before that I-140 filing. And that I-140, that priority date will then determine, according to your country of birth, when you're able to take the next step in the process. In here, adjustment of status or consular processing. And that's subject to the visa bulletin. So if you are Canadian born or you're not born, I guess is the best way to put it. If you're not born in China, India, Mexico, then you are in what is called the all other countries category, or the Philippines. You're in the all other countries categories, and the wait times tend to be much less because there are a lot less applicants from those countries than there are from Mexico, India, China, or the Philippines. And your case is likely to process faster, but you're subject to those wait times according to your country of birth and your category. Once it becomes current, your priority date or your place in line is called up, then you're able to take that step to file for adjustment of status or to commence consular processing. That is when you are declaring immigrant intent. When you take this step in the process, step 3, that's when you're no longer likely to get an extension of a TN. So it's very important before you go into step 3 that you look at your visa. You look at how long it's valid for. We often recommend that even if it's premature in your visa process as far as your TN status, that you would get an extension as long as possible of your TN before you file that 485 or before you commence your consular processing, so that you stay in valid status throughout this whole process. Now, you will request what is called work authorization as part of the adjustment process, but it's always good practice to have an underlying visa that is valid until your green card's actually issued. So step 3, when it comes to intent, that's when your immigrant intent is declared officially by filing that adjustment of status application. And that's when it becomes complicated, if not impossible, to extend your TN visa. So very important to take these steps properly and understand what your actions are and the consequences of your actions when you're taking these steps in the process. And then the consular processing we'll add that to the step 3 here. That's when you choose to process through the consulate in your home country. So in this case, we'll refer to Montreal. That's who processes all immigrant visa cases in Canada. Once you commence that process with a national visa center, that's when you've declared your immigrant intent. And again, that process won't begin or can't begin until your priority date is current. And at that point, then you've declared your intent to immigrate permanently to the United States.
Moving on to the family-based options to get your green card here. So U.S. citizens can sponsor spouses, children who are unmarried and under 21 years of age, parents, and siblings. It's a little different if you are a lawful permanent resident or a green card holder. You can sponsor spouse and unmarried children under 21. Now, there's a certain classification for immediate relatives that includes spouses, minor children, and parents. And for those individuals, you can petition for your beneficiary and you can file an I-130 petition, which is the petition for an alien relative, and Form I-485 to adjust status at the same time if you are in the United States and you entered in a valid status. So if you entered on a TN, you can adjust your status if you are married to one of these immediate relatives. Some important information to keep in mind. There are family preference categories. They're listed as F1 through F4, and these categories are subject to the visa bulletin. So if you fall into one of these, you have to wait for a green card to become available before applying. And this is primarily referring to non-immediate relatives or certain petitioners who are lawful permanent residents. Immediate relatives, again, are not subject to that visa bulletin, meaning that there is a green card readily available to them, and that process is a bit quicker. While you file an adjustment of status, you can also file for a work permit and travel permit. The work permit is known as the EAD card, and travel is advanced parole. These are available to file at the same time as that 485 to adjust status. In response to the one question in the chat, can you receive an EAD before the green card is processed? Yes. So that is why we file typically with work authorization concurrently with that adjustment. Usually those arrive much quicker than the green card, right now about 4 to 6 months or so. And once you have that EAD, you are free to work anywhere in the US for any employer. And then to touch on how long is the time frame from TN to green card through marriage to a US citizen. Right now, we're looking at about 12 to 18 months for the adjustment of status process and roughly 2 years to go through the entire consular processing phase, but they're really relatively the same. Sometimes adjustments of status can be a bit faster. And just to reiterate again, you need to keep in mind that if you are in a non-immigrant status, such as a TN, that status should remain valid through the I-485 process, as Jeremy mentioned. Now, looking to the differences between adjusting your status and consular processing from a family standpoint. So while doing the adjustment of status, you are inside the United States and you must stay here while processing. Travel outside of the US during this process will lead to an abandonment of your application, especially if you have an underlying status that does not allow the dual intent to immigrate and work temporarily, such as that TN. So you need to make sure that you have plans in place and are able to stay put. Like we just touched on, you do have the option to apply for work authorization, where you'll be granted that EAD before your green card, and that again allows you to work freely in the US. And you do also have that option for advanced parole, which is your travel authorization. This is typically only recommended in situations where you foresee having an emergency situation outside of the US that immediately requires you to leave. Now, consular processing, as Jeremy said, this is often the preferred route if you are living and working outside of the United States, if you have a reason to travel, or if you're concerned about the dual intent risks. Again, since the TN does not allow that dual intent and is only a temporary non-immigrant status. Consular processing takes place outside of the US, and it concludes with an interview at a US consulate abroad. You will attend an interview at that consulate where, if you're approved, you'll be issued an immigrant visa in your passport, which will then allow you to enter the US, at which point your green card will then be produced. Now, in terms of maintaining your status during the process, again, to touch on what Jeremy previously mentioned, your TN status should remain valid through the green card process. If you plan to adjust your status to get your green card, your TN should be valid to get you through to when you receive that green card, or at the very least until you receive that employment authorization. If you are pursuing the adjustment of status, again, avoid traveling outside of the US unless advanced parole has been approved. But even in those cases, travel may still be risky because at the end of the day, your admission is still going to be up to the border officers, and they can still deny you entry even with that advanced parole document. And if you are consular processing, that means no 485 application to adjust status has been filed, and then you can continue to travel on your TN while that case is still pending. Just real quick to answer a couple questions in the chat here. Would the EAD come in around 6 months or so? Right now, we are seeing them arrive pretty consistently in about 4 to 6 months. They do arrive much faster than the actual green card in most cases. And then, does the EAD apply to sons and daughters over 21 years of age with the adjustment of status? Yes. So anyone who is applying for an adjustment of status, you are also eligible to file for that work authorization to get that EAD card.
But not for a son and daughter over 21. So that was for son and daughter. So for immigration purposes, so everyone understands, a child for immigration purposes is a son and daughter under the age of 21 who is also unmarried. So if your child turns 21 or they get married, they no longer qualify as a dependent, which can be a complicating factor if you're doing this green card process. So if you have children that you want to potentially, be a part of the process as a dependent, you need to take action when they're young to make sure that they don't age out and they don't lose the ability to obtain that green card as a child. So once they hit 21, they're done. They're on their own, or once they get married. And going back to the EAD question and how long does this arrive? Well, it arrives whenever the government decides to issue it. I would say 6 months is very safe. We did get one this last week in a month, which is crazy fast. And when you're talking about Trump administration and how it's impacted the processing of cases, we've started to see with consular processing cases that things have slowed down a lot. So although it has been taking about 2 years for a consular processing case, my guess is that's going to probably creep up towards 3 years with what they're doing with consular processing, the Department of State under the Trump administration, as well as their increased scrutiny with that process. But on the flip side, even though they've instituted mandatory interviews for green cards again, which is different than the Biden administration waived all interviews So if you filed for a green card and they thought the evidence was sufficient, your green card would just show up in the mail without interview. So, which is crazy because when Rebecca, you've been working with us, it started was it during COVID?
No, it was September 2023.
Okay, so it was after
Right
COVID,
after.
but it was right in the middle of Biden, and it's like no interviews. We don't have to go to USC. So well, we've seen a change, and now we're going to naturalization interviews again. Now we're going to green card interviews again. But for the longest time, those weren't happening. So we've been seeing that those interviews reinstated, but we're seeing USCIS processing speed up, which is kind of crazy. It's going faster, even with interviews. We just had an interview scheduled in 5 months after filing for a green card through marriage. So we're seeing a trend of consular processing slowing down and adjustment of status speeding up. So going back to questions here, will there be a webinar for the options for over 21? So if you fall under F1 and F2. So that's a family-based discussion about F1 and F2. And we will potentially do a webinar that covers those family-based options. But if you're over 21, and you're listening, again, I need to emphasize, get it taken care of before they're 21, because even though there are options when they're 21 or older, the wait times are excessive. You're talking decades, 10 plus years to wait for a green card if you're being sponsored that way. So once a kid becomes an adult, once they get married, they move to other categories where the wait times on the visa bulletin are extremely long. So getting it done before they turn 21 is very important. Oh, this is a really good question. You want to answer that one there, Rebecca? How quickly after marrying a U.S. citizen can a spouse start the process of filing a green card for a TN visa holder?
So this is a big point of conversation. So really the main concern is how quickly after entering the US can you file for the green card from being on a TN. So there's something called the 90-day rule. So if you are in TN status and you enter the US, you should be waiting at least 90 days before filing for this adjustment of status. Waiting that 90 days overcomes the presumption of that immigrant intent. If you file an application for a green card, such as that adjustment of status, too soon after entering in a non-immigrant status, it raises some red flags with USCIS that when you actually entered the US, you had the intent to remain permanently. And that's not what your intent should have been. And as we previously mentioned, that intent can change after you have entered. That's why we want to wait that 90 days to show that there has been enough time for that change of mind to occur. And one thing to note too, there is a medical exam involved with the adjustment of status process as well. That can also be seen as declaring immigrant intent if you get that done and completed too early. So we always say wait until after that 90 days to get that medical exam completed as well.
Yeah, taking any of those steps that could be seen as moving towards getting that green card could be seen as declaring an immigrant intent. But answering the question of how quickly after marriage, well, once you're married, you technically qualify. So if you had entered on your TN visa a year ago and then you get married today, well, you're way outside of the 90-day window that Rebecca just discussed. So you could file potentially immediately. So Rebecca's correct. It's more about when did you get your TN, not when the marriage happened. Because as soon as you're married, there is no wait period. Once you're legally married, you can file right away, as long as these other conditions are met. Someone asked if this recording is available. Yes, all of our webinars and recordings are available after they're completed on our YouTube channel, on the Richards and Jurusik YouTube channel. So if, where are we at? This QR code will allow you to register for these upcoming webinars, and I'll plug that real quick. Travel to Canada with a DUI or criminal record. and then discussions on L1 visas for Canadians expanding business to the US. This QR code is where you're going to be able to find our contact information. And if you go to YouTube and you look up Richards and Jurusik Immigration Law, you'll find our YouTube channel. And these are posted to our YouTube channel after they're completed, so you can find it there. Would you recommend waiting to file for a green card due to the changes with the Trump administration? No, I don't see any reason why you would do that. You're just going to delay how long it's going to take you to get your green card if you do that. I mean, and Rebecca can chime in with her experience too. We
Yeah,
haven't seen any substantive changes that are going to impact people that are doing the process lawfully, don't have any criminal or immigration violations. We haven't seen a change in that.
yep. I'm telling everyone, unless you have committed some egregious fraud in your past or robbed a bank recently, you really shouldn't have any any big concerns here. And at the end of the day, the law itself has remained the same. The process to qualify and apply has remained the same. It's really just changes in processing times that we're primarily seeing right now, but nothing to be too concerned about at this time.
Yeah. And I 100% agree with that. We haven't seen anything outside of the normal that you would expect. They're just publicizing it more, so it's all over the place. For EB3, does the job title and description matter? Like, does it increase your chances of getting a green card if you have a manager in your job title or something up the chain? So it doesn't. It matters, but probably for reasons that you might not understand. So in the end, you can do an EB3 for any job. It doesn't matter. It could be for anything that a U.S. employer determines that and does the recruitment process for, and can't find a U.S. worker to do the job. Okay, that it could be any job. We've done perms for all sorts of farm workers, truck drivers, professionals. It doesn't matter as long as the employer can show that there are no willing and qualified U.S. workers for the position, and the perm process can be done for that type of a role. Now, what's important to understand, and the key to success for a perm, is the area of intended employment, because that's where these ads are going to be done. And how likely is it for the employer to find somebody with those minimum qualifications in that area? So the example I like to give is here in Buffalo, we've done many perms for employers. One of them was for this guy that did, he was a tungsten engineer, highly specialized area. Well, the likelihood of finding anybody in the Buffalo area who has experience in tungsten ore processing, very slim to none. Well, that perm sailed through because there isn't anybody in Buffalo with that training. Well, there is now because he's here, but that is such a specialized area. It's very, very difficult for an employer to find somebody to fill that role, and that's really what perm's designed for. Now, if you're trying to do a perm for a fast food worker, a frontline fast food worker, that's probably going to fail because they're going to post that ad and they're going to have hundreds of applicants in the area that are going to qualify for that job. So the success of perm really is dependent on how hard is it for an employer to find somebody to fill that role, and the minimum qualifications for it. So the more advanced the education requirement, the more certifications, the more experience, well, you're weeding out numbers and numbers of population of people that would qualify. So the less the qualifications, the easier it is for them to find a U.S. worker. The higher the qualifications, the harder it is to find somebody. And also, where is it? If you're in New York City or LA, you're going to find a lot of people. It's going to be easier. Whereas if you're in the country somewhere, it could be a role that has fairly low requirements, but they can't find anybody because of where it's located. Rebecca, you want to remind us?
Yeah, what the EB1 categories are.
Yeah,
So
what EB1 is.
it's split into 3 different sort of classifications here. We have the EB1A, which is for extraordinary ability. So This is also known as the Einstein visa. So think of those who are in the top 10% of their field, or those who have won Nobel Prizes, Pulitzer Prizes, really top level individuals like that. The EB-1B is for outstanding professors and researchers. And then the EB-1C is for multinational managers and executives. So say if you are in the US on an L1, you can transition to a green card through the EB-1C program. The EB-1C doesn't require you to have an L1 to start with, just as long as you meet those qualifications. But that process does skip that traditional labor certification process that we discussed, and goes right to filing the I-140. And then once that's approved, the green card application. Does a dentist TN do better than a management consultant TN? So what it comes down to is what role that you are playing, or what your duties are, your day-to-day duties, which profession they align with better, and what your qualifications are. If you're a dentist, you typically have a degree in dentistry. Management consultant, that occupation faces a lot of scrutiny because there is typically a lot of fraud in that category, because you don't need a bachelor's degree per se to qualify. You can rely on experience. And it's kind of broad. So it really comes down to what exactly you're going to be doing in that role. If your qualifications match those of a dentist might be a good fit for you for the TN category.
EB-1B, outstanding professing researcher requirements. We're not really going to cover that today. That's really specific to that category. If you do want to know what those qualifications are, you can reach out to us directly. Our contact information is on the screen, and we will be glad to send you information about that category and what those minimum qualifications are. If you file your 485, Step 3, after you get your TN approved for 3 years, after 3 years with your TN expiring soon, will you still have received your green card? Potentially, yes. So if you have 3 years left on your green card and you file for adjustment, typically within a year, you're going to get that green card, that 12 to 18 months. So if you have 3 years left, that's typically more than enough time on that TN to allow you to continue to work while you're waiting for the green card. Also, you're going to have that EAD card that's been issued as well. That will allow you to stay here and work on that EAD while you're waiting for that adjustment of status. But I haven't seen a case in all my years that's taken longer than 3 years to process. Not an employment-based adjustment. Once you're current, and that's what's important to understand, once you're current on the priority date on the visa bulletin, that means that they're immediately able to approve and issue a green card. There is no longer a wait time for that process. So if you're filing that way, then typically it's going to arrive within that time frame.
Do we need to get a long form birth certificate from our birth country? Yes, I recommend everyone get one. It is a requirement that the USCIS.
That's definitely a Canadian question right there.
Yes.
They have that little birth certificate card thing. Yeah, throw that thing out. It doesn't work for U.S. immigration.
Yep, make sure both parents are listed on that. I know if you're from Ontario, those certificates take quite a while to arrive. So if you're going through this process, I recommend getting that as soon as possible. And then the next question too, what happens after you get a green card? Does it expire? So there is an expiration date on them, and it will either be 2 years or 10 years, depending on which process you're going through. A 2-year green card is a conditional green card. That is for individuals who went through the marriage-based application route and who have been married under 2 years at the time they received the green card. In that case, then there is a separate application called the removal of conditions, and that is where you file to get your 10-year green card. If you are getting an employment-based green card, it is typically good for 10 years at a time, at which you would reapply to renew it. It's not a whole new application to qualify you. It's just renewing the green card itself, Form I-90, and that you do when it's nearing that expiration of that 10 years.
And the last question on here, no, EB1C category is only for executives and managers. So the only way you can do an EB1C is through intercompany transfer. Now, can you do it without an L? Yes, you can. You can go straight to EB1C. You don't have to ever have an L. So if your employer just wants to sponsor you for a green card and you meet the requirements for it, they can sponsor you straight up for a green card. You don't have to have the L first to then go to a green card. So you could be sitting in Canada right now, you meet the requirement for an EB1C, and they could sponsor you directly to go to EB1C. You don't have to get an L first. There are disadvantages to that, though. One is you're going to go through consular processing, and consular processing for employment-based cases is extremely long. Also, you're not going to be able to work in the US while you're waiting. So most people will get the L first because it allows you to come and work in the US. Then they do the EB1C. So the L allows you to work here while you're waiting for that EB1C to be approved. Because wait times can be long. It depends on your country of birth, how long that's going to take. But yeah, you don't have to have an L first. You can be sponsored for EB1C if you meet the requirements without getting the L first. Thank you everybody for tuning in to another webinar. Hopefully you were able to learn more about the process from a TN to a green card and what those options are available. I think the most important thing to understand is yes, you can go from a TN visa to a green card. And what I like to tell people, it's the same exact process as going from an H-1B to a green card. It's through PERM. That's the typical process, or through marriage. So those options are available to TN holders just as they are H-1B visa holders. Any other questions you have, our contact information is on the screen, so feel free to reach out to us directly. And if you have interest, tune in and register for our upcoming webinars as well. And if there are webinars that, and we had a suggestion, if there are webinars that we haven't done that you have interest in, we do these for you to answer your questions and help you understand what your options are. So we'd be glad to receive your suggestions. If there's a webinar that you would like us to do for you, let us know. And if it makes sense for us to do it, we'd be glad to do that for you. So thank you again for your time, and I hope you have a great day.